The evidence that was tampered with in this case was a firearm that was used to kill a person. It was a firearm in a murder case. You know, the normal tampering with evidence case that we deal with is a person who's getting pulled over for a traffic offense and is getting rid of drugs that they have on them. But this, when people think of tampering with evidence, it's this scenario that people think of, and that you never get that. Hiding or getting rid of a murder weapon. And that's what this case is about. It's not just more serious, it's probably the worst form of the offense.
Certainly, this started as an aggravated murder case. There's people with this, in this matter, charged with aggravated murder. And usually when you see the people charged with the lesser crimes, in my experience, those are the ones that hang on and say, I didn't do anything. And Carla never did that. Your Honor, Carla's had an incredibly rough life. She has a dual diagnosis mental health issue as well as a serious substance abuse issue, her drug of choice being crack cocaine. In part and parcel to the rough life she's had as a drug user and someone who's been in and out of jails, treatment facilities, and I believe prison, she also lost her child. Her son was in the custody of the Cuyahoga County Department of Children and Family Services. I think she had her parental rights completely terminated. However, she did maintain communication with her son, Christopher, after that occurred. Christopher had absconded from a group home in Cuyahoga County and became involved in this. And when he called her for help, I think she, in a bleak moment in time, just tried to do whatever she could do to help her son. And I think no matter what court orders say she is or isn't his parent, I think she'll always be his parent, at least in her heart.
Ms. Ferrone, you have the right to address the court before you're sentenced. You can say anything you want. Is there anything you want to say?
Yes, I would like to read my letter, please.
Go ahead.
It says, first, that I'm glad that the family is here, but they are not. So I'm sad that they are not here. So I can look them in the eye and say that I know that there are no words or actions other than bringing their son back that could ever relieve the pain of losing the child, family, and friend in such a terrible way. And I'm sad for you all. I'm so sorry about your loss, and no matter what kind of mother I have been due to my use, I would be just devastated if it were my own child. There is not a night or a day that goes by that I don't play this over and over in my mind. And if I could take it all back and give it all back, and give your child back and fix everything for everybody, that I would. My life hasn't been that much. I would give my own life, Your Honor, if I could fix this and give a child back. I was high when the phone call came in, and I really did not know what to do. I was never told the details, nor did I actually go to Fox Run Apartments till the next day. Christopher did not call me to ask me to remove the gun. He thought the detectives that had already had it. I want to make that clear. I was there for something else. But when I did come across the bag, all I could think about was my own child. My judgment was clouded by the time that by the drugs that I was on, and the fact that I was on medication, on no medication to rationalize my first thought. When it all came together, the fear in so many forms set in. I've never dealt with a situation of this magnitude before, and I did not know that a young man had died. All that I could thought of at that moment was to help my own child.
For the state of Ohio?
The defendant has a lengthy criminal history starting in 1997, going all the way through the instant offense. There really is no substantial break in her criminal history. She has a number of prison terms that she has served. She's had a number of opportunities in treatment, and nothing has really proved to be successful for her. The facts of this case are more serious than the average tampering with evidence. The defendant knew that this gun was used in a shooting. Her son knew that that shooting led to the death of someone. Her son gave her information when he made a call to her immediately after this shooting happened. He told her that his friend had shot someone, that he tampered with a gun, that he cleaned it with Crown Royal, that he needed it to be taken away, that he did something bad, that he tampered with evidence. The defendant knew all of that and chose to come to the Fox Run Apartments, chose to get that gun from the location where he told her that it was in the bushes, and on phone calls to her son and her son's girlfriend said things like, I got it, it's taken care of, I've handled it, I got it. And she said things like that repeatedly. So the defendant knew exactly what she was doing and exactly what she was taking and what her son was risking as a result of his own conduct. The defendant was not actually separated from her child at the time that this occurred, Judge. The place where this robbery and homicide was planned was actually the defendant's bedroom in Melvin Harris's apartment. The defendant's items were all still in that apartment. They were all still there. She had been living with Mr. Harris at Fox Run, as well as her son. So they had been in communication. They had been talking with one another. All of her personal items were in that room where this homicide was planned. The defendant was at the apartment only an hour before the Willoughby Police Department came to that apartment to search, to talk to people that were there, and to talk to her son. So she was there, she was retrieving items, she was retrieving evidence. Originally, she wasn't forthcoming and truthful with the police. It was once she didn't want to go to jail, she called the police back in and she began giving them truthful versions of events. But at first, the defendant was reluctant to tell them that she had any involvement, that she had any knowledge of anything. She told them that her statements of, "I got it," were relating to getting an apartment, not about getting the gun that was under the bushes and the reason why her son was calling. So while I do understand that, and acknowledge that Ms. Ferrona wanted to do anything that she could to protect her son, that she wanted to watch out for him, that she wanted to be a mother to him, this was a serious crime that was committed using this firearm, and she had knowledge of that, which is why this is a more serious form of tampering with evidence. And we ask the court to impose that prison sentence. Additionally, we ask for count 2 of the indictment to be dismissed. Thank you.
I've considered everything that's been said here today by the defendant, her lawyer, the prosecutor, the recommendations from the sides. The court does note, as alluded to by the prosecutor, that the evidence that was tampered with in this case was a firearm that was used to kill a person. It was a firearm in a murder case. You know, the normal tampering with evidence case that we deal with is a person who's getting pulled over for a traffic offense and is getting rid of drugs that they have on them. But this, when people think of tampering with evidence, it's this scenario that people think of, and that you never get that. Hiding or getting rid of a murder weapon. And that's what this case is about. It's not just more serious, it's probably the worst form of the offense. Getting rid of a murder weapon. And interesting to me is that you said all you were thinking about was helping your son. We were also obviously thinking about helping your boyfriend, because you used that gun to then go take care and clear up a debt that he owed with his drug dealer. Instead of just getting rid of the gun, you took advantage of that, having that gun to get some benefit to you and your boyfriend. Or at least him, but you helped him with it for that. No factors indicate it's less serious. As for recidivism factors, there's a lengthy history of criminal convictions. Goes back 30 years, 29 years. Defendant has served multiple prison terms before. She's been sentenced to prison on 5 separate cases that's resulted in 4 separate prison numbers. She's been on probation before in the past, has violated her probation on multiple occasions, so she's not complied with previously imposed sanctions ordered by courts. No factors indicate recidivism is less likely. It's a mandatory prison term required due to the firearm specification. Prisons consistent with the purposes and principles of sentencing. Therefore, it'll be the sentence of this court. Then on count 1, defendant served a term in prison of 24 months. In addition, the court imposes a mandatory prison term of 1 year to be served prior to and consecutive to the 24-month prison sentence for an overall term of 36 months in prison.